welcome to Value Talks. Value Talks is an initiative by myself, Major Jayesh Verma Shaurya Chakra and Colonel Manish Kochar. We co-founded this, and this is an advisory platform for matters related to finance, legal, career, and health. Basically, things which are valuable to individuals and to societies and to communities. In this, it is our effort to invite experts from the respective fields and ask them to share their expertise on these relevant matters. Without much ado, I'll now request Advocate Sovi Bipneet Singh to start the talk today. Welcome, Advocate Bipneet, and welcome, Advocate Massey.
Thank you, Vipul.
Pleasure.
Pleasure. And I guess now, as we are starting, this is a very interesting and a very important issue which we are all witnessing in our day to day, or we ourselves are experiencing, since there was a boom in our country as far as the real estate was concerned. Along with it, the bad side of it also was faced by a lot of home buyers. And eventually, lot of projects actually could not see the ray of light and was gone down the drain. Now, as per today's topic, I will try to put some questions which personally I also want to know, and I feel that our audience will also be interested in getting answers of a lot of questions which could be similar. They also want to know, and as we all know, in the end of the session, we'll also have a question and answer round. So, Mr. Massey, if I start this session, the first and foremost thing which I guess we all want to know from you is this: what exactly this insolvency and bankruptcy code is all about, and what is insolvency and bankruptcy code, or we say IBC, or I guess in more commonly we say NCLT. So I guess this will be the best way to start. That you please explain us a bit that what exactly is this.
Sure, pleasure. Good evening, everyone. So, as Mrs. Sovi have just asked this question, so the Insolvency and Bankruptcy Code, as it's known by its abbreviation IBC, is the law. And NCLT, which stands for National Company Law Tribunal, is the court. Now, the Insolvency and Bankruptcy Code, the reason why it came into being was to, as a corrective measure, improve the performance of the small scale industries and also the business at large. This was to be done by doing away with the long run and tedious process as was involved in the old regime of laws, the Sick Industries Act, the BIFER, the IFER, the SARFAESI Act, and many others, including the old insolvency laws. Now, what it does is it consolidates everything and brings it under one regime, that is the Insolvency Bankruptcy Code, which governs the insolvency of the companies. That's one. Two, the partnerships, especially the LLPs, limited liability partnerships, and also the individuals. Besides that, NCLT is also conferred with the exclusive jurisdiction of the disputes relating to companies. This, I don't think, will be required as a topic, because that's a topic in itself. But broadly speaking, this is what the IBC and NCLT is about.
Okay. So, Mr. Massey, as you just told us what actually is IBC code is and what is the NCLT, and it's a code and that's a act, I guess everybody is pretty clear about that now. The question which comes in the mind is, who can actually initiate insolvency proceedings? And furthermore, as of the topic of today is related exclusively for the home buyers, are they also covered, or they can initiate the proceedings in NCLT?
So, as I take it, your question is that who can initiate insolvency proceedings?
Yes.
Now, so broadly speaking, the insolvency proceedings can be initiated by the corporate debtors, the financial creditors and the operational creditors. There is broad broad difference between the two. Essentially, the operational creditors are the people who, or the companies who provide services, goods and services, and financial creditors, as the name would suggest, would be banks. And the good news for the home buyers is now, after the amendment, it covers the home buyers as well.
Okay.
What was your second question?
Actually, you have answered the thing. My second question was related to the home buyers only, which you have just answered that yes,
Yes,
they
so
are
let
also
me.
now covered under financial. But one thing, Mr. Massey, can you just elaborate a bit more about who exactly are the financial creditors and who exactly are the operational creditors
Okay, so
for the better understanding of the audience?
so operational creditors would be companies or individuals or sole proprietorships which are offering goods and services,
Okay.
essentially. Financial creditors will be banks, financial institutions, companies, and individuals, and including home buyers. Now, the home buyers were initially in 2016 were not included in the definition of home buyers. But looking at the, as you just mentioned, the problems with the real estate sector and the most of the companies, the real estate companies going insolvent, there was a need of the hour that that some kind of a relief is given to the home buyers, because they were neither defined under the financial creditor or secured creditor. Operational credit, of course, they will not be covered. So there were, first there was an ordinance in 2018, followed by two judgments of the Honorable Supreme Court. One was Chitra Sharma, which was a landmark judgment, in which the right of the home buyers as a financial creditor was recognized pursuant to the ordinance of 2018. Thereafter, the amendment came in, which, this is section 7 and section 5, 8F 1 and 2 precisely, which define that home buyers will fall under the category of financial creditors with certain criterias. Should I mention those criterias, or would you like to keep
No,
that
no,
for?
no, it will be too deep in that time because I guess you had actually explained what exactly was the want of my question. Mr. Massey, we understand that now if I'm a home buyer and my project is totally into rashes right now and I'm not getting anything. So if I decide to go before Honorable NCLT,
Mhm.
when I can actually initiate the proceedings? And following to this, if I club two or three my own queries in this particular question itself,
Mhm.
one is that when I can initiate, that means is there any limitation that after this time I cannot go before that particular tribunal? Is there any pecuniary jurisdiction requirement also there?
Mhm.
And one very important aspect, which also I love to club with this question only because it will complete the whole sense what I really want to know,
Mhm.
is that the limitation part, the pecuniary jurisdiction part, and can a home buyer individually opt to go against a particular builder or they can go collectively? Plus, what is better suited if they go individually or collectively?
That's a very valid question. So, in order to initiate insolvency, there has to be a claim. Now, the claim, as per earlier, there was no kind of this thing embargo, or let's say a limitation on that, which was 1 lakh above. Anything which was 1 lakh above was included as a claim. But in view of the COVID, the notification of the government, central government came, and the pecuniary jurisdiction has now been set at 1 crore rupees. So if
Okay.
your claim does not fall, is below 1 crore rupees, essentially you cannot make out a case. But I'll answer that in the second leg. Uh, the requirement, as you said, whether you can go individually or collectively. Now, earlier, before the amendments and before how it was defined that the home buyers are now financial creditors, amendment to Section 7 and Section 5, uh, the requirement is that 100 home buyers or 10% of the home buyers of a particular project. Now, the project is not the builder. The project is the project involved in which you are involved in insolvency, or which is in dispute, or in which you have a claim. So it has to be of that 10% has to be of that particular project, not against a builder. A builder may have five parallel projects. So this is very important. This becomes a technical point uh, in on which probably your petition may get disallowed or dismissed.
Okay.
Now, I think I've answered the pecuniary question and I've answered the requirement
Yes.
of individual. And so now the question of going individually goes out of the picture in view of the amendment. But this is better. If you see for the larger good, not all individuals will have a claim of above 1 crore rupees.
Yes.
So if they go in that group, even somebody who has a claim smaller than 1 crore rupees, his claim can be clubbed and he can maintain, which he would not have been able to maintain in view of this notification.
Okay. 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 So basically, what you mean is actually going collectively is actually the most convenient way. Say per se, if one home buyer has a claim of meager 5 lakh or 7 lakh, 10 lakh rupees, but as you just mentioned, that minimum 100
Home
people
buyer.
or 10%. So
What in?
obviously, it's a easy. It's not a rocket science to understand that if
Exactly.
100 people multiply by 5, it will be much more than the pecuniary
Obviously.
jurisdiction. So obviously,
Obviously.
that's an indication to come collectively rather going individually.
Absolutely.
Okay, Mr. Massey, if the builder is turned bankrupt,
Mhm.
now at this stage, what can a home buyer have? What remedies are left with the home buyers now?
If the builder goes bankrupt, the immediate thing that the home buyer should do is uh, probably to get in touch with a professional or a consultant and to file its claim and file its claim within time. Now, this is important because I would have liked to explain the process first, but let it be. The process involved in insolvency includes a public announcement where claims are invited against the builder who's gone bankrupt or insolvent, as we would like to call them. Uh, Once that happens, the claims of all the claimants or let's say creditors are invited, which includes the home buyers, and they should file their claim within 90 days time from the date of announcement.
Okay.
Now, there have been cases where people have not, or probably because of lack of knowledge or lack of awareness, have not, and then they have faced serious consequences.
Okay. 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 So technically, there is a time limit for everything in a procedural as far as the procedural aspect of the proceedings, which has to be followed in NCLT.
Yes.
What are the safeguards available for the home buyers in IBC? Because see, home buyer is an individual in the beginning. He is an individual.
Mhm.
I don't know. There are now associations or WhatsApp groups of all the home buyers to a particular respective project in all the way they are associated. But
Mhm.
if let's take a picture, let's understand that way that a person is individual. Now, how he can safeguard? What are the safeguards available for him under IBC?
Okay, so as I've already mentioned slightly, that pursuant to the Chitra Sharma judgment, which
Yes.
was in fact challenged in the Pioneer Urban Land case, uh, the constitutionality of the amendment of 2018, but the amendment has been upheld, which is the good news. And pursuant to the amendment, the right of the home buyers, which was the gray area, has been recognized statutorily by amendment of Section 7 and Section 5 to
Okay.
include the home buyers and their claims with the caveat and criteria that I mentioned, 10% and 100. And of course, now in view of the notification, that 1 crore thing. Now, apart from that, uh, the after in the insolvency process, the project cannot be revived. Liquidation, the option. Now, in that, we have something called the committee of creditors. Now, these financial creditors, in which the home buyers are included, get a right to representation and right to vote in that committee
Okay.
of creditors. So, committee of creditors is a specialized body which includes representatives of the banks, financial institutions, who have the technical know-how how to revive a company or how to generate investment, uh, ask for the bidders, look at the bids, which is the best option for revival, or let's say the best financial option as far as selling of the assets are concerned. So you get a right to representation and right to vote, a right to say as far as the liquidation of the assets, what do you do with that money is concerned.
Okay.
Also, the home buyers get a right to to present their own resolution plan. So what happens is that once the proceedings are initiated, there's a profession called the resolution profession is appointed. He takes over the assets and control of the company. Thereafter, there is something called a moratorium to protect other litigations. And then there's a committee of creditors which invites resolution plans, how to revive the company, or let's say if it's going to liquidation, who will give the best bid or best offer. So in that, even the home buyers can present their resolution plan. Apart from that, you have a right to representation through your advocates who look after your interest before the adjudicating authority, which is the NCLT court, who's overseeing all this process. So
Okay.
I think I can safely say that there is, and even before this, in the earlier regime, there was no safeguards like these. So it is a landmark kind of a step forward to ensure that home buyers protect interests are protected.
Okay. I must say that you actually explained in a very simple and plain manner. It was really understandable, but I guess this is one side of the coin. Now, the other side is what you, Mr. Massey, just explained is that somebody puts its claim before NCLT and all this process which you have explained, we got to know about that. Say the builder voluntarily applies for the insolvency.
Mhm.
Now, in that case, the first and foremost thing which comes in my mind is how a home buyer will be able to safeguard himself, because most of the time he might not be able to know it,
Mm,
that some kind of proceedings are going and the builder has applied for insolvency. So
mhm.
is there any mechanism available, or is there any ways, or is there something cautions which a home buyer can adopt to actually save his position in this kind of situation?
See, Mr. Sovi, I would like to answer a question by asking you a question. When do most of your clients come to you?
When they are in trouble and the things are have gone haywire.
Exactly. So I think the best way to answer this question is that you don't wait for the trouble. You rather be alert and appoint somebody or be in touch with a professional consultant, be it a real estate agent, a competent CA, a lawyer, or whosoever who's professional, who's competent to deal with these situations. He can guide you best in as far as what is the situation at ground, what is the progress as far as construction is concerned, what is the news in the market as far as that particular project or the real estate house is concerned. And that is the best way of being aware of situations. Once you do that, and once you get to know, that is the second like once you get are aware that something has gone wrong or he has filed for insolvency. I think the first thing, as I've explained, is that you have to draw up your claim. It's advisable that you go through a CA, a professional, a lawyer, to draw up your claim, and you file it immediately with the NCT. I'll tell you some examples I've experienced and matters which are dealing with.
Please, it
So
will be very helpful.
yes, because home buyers may not be aware of this. There may be situations where if it's not a very big project, or let's say a project which is in collaboration with two, three builders, a consortium side of kind of a thing, where one unit of flat has been sold to two different parties, or let's say three different parties, and there is an interstate dispute between the consortium members, and the company goes into insolvency, either self-applied or somebody files for insolvency. Now, in this case, the person who has left out, there may be a situation here also where the builder may have given you a letter or a notification saying that I have already filed a claim on your behalf because you purchased it from me. But when you look at the claim, your flat may not be have been included, or it may have been mentioned in somebody else's name. Now, you are an honest bona fide buyer, your hard-earned money has been put there, and you probably may be sitting back that your claim has already been submitted by the person or the agent you purchased it from. Ultimately, to find out that this was not your claim, and when the claim list comes out, your flat number is mentioned against somebody else's name.
Oh,
You're getting my point. So these kind of frauds and these kind of happenings are there. So it's always advisable that once you, as soon as you get to know that the insolvency proceedings or matter is has reached the NCLT, or the or notices have been issued, or publication has been issued, you immediately consult a professional, and you drop your claim and you submit your claim personally.
okay, okay. Mr. Massey, let's presume that the proceedings has been initiated against a particular builder before NCLT.
Mhm.
Now, honestly, sir,
Mm.
are there any chances of the project getting completed?
It has in the past. Now, you see, as I've explained, the Committee of Creditors is a specialized body which includes people from the financial sector, the economic sector, the CAs. There are a lot of professionals there, so they know how to revive a company, or if it cannot be revived, how to best utilize the assets of the company, how to call for the best bids, things like that. So there are a lot of options which are available, unlike any other probably forum. So what you can do is you can sell off to obtain money of the assets of the company. You can, in the alternative, invest funds like stress funds.
Okay,
What you can do is you can ask the Resident Welfare Association, the home buyers, to come up with a plan to revive the project. You can call independent builders. You can ask them to give their bids for revival of the project. So there are a lot of options as far as the Committee of Creditors is concerned. Once the matter is seized before the NCLT. Now, I'd like to add something here. What happens is that there may be a question that how much time will it take? So this process may not be a straitjacket formula, although there are statutory deadlines and strict time frames which are mentioned, which I may probably mention later. But these may be adjusted according to the situation. The trend may be to go beyond the deadline, but this is for the larger good,
okay, okay,
which which is because of the things that I mentioned, that looking for a good potential investor may take time.
okay,
There may be negotiation of rounds, 4, 5, probably many.
okay. So, sir, putting forward what you just have actually explained us, why can't the builders not make a backdoor entry and again stall the process of the work of the project? Or are they able to do, and or there's some kind of estoppel to them?
That's a nice question.
Because
And
because that thing actually follows after this. Because if what
yes,
is happening, he can also come in.
yes, by wearing some other mask or some
Yes,
other mask.
exactly, exactly.
You're right. You're right. So, which has happened, and not just in this, and in other industries like the mining industry and other companies and sectors. So, there is a statutory safeguard, which is called the related party safeguard. where anybody who is a defaulter or has been in touch or is in connection, a close connection with the defaulter, which in this case would be the builder, is forbidden from participating in these proceedings. So if a party gets to know this, even if it is at the last leg, the negotiations, everything, if
Okay.
he gets to know this, he can raise an objection and file an application and raise his complaint before the NCLT that look here, there is a party which has been participating, but this is what we found out. He is a related party in law as defined, and therefore this has to go. This has to go. Like this party cannot be allowed to continue. So there is the statutory safeguard against these kind of activities. Now coming
So
back
meaning
to,
thereby,
I'll just,
oh,
yeah. But having said that, if you see the role of the defaulter or the builder is limited here, because once the insolvency proceedings have been initiated, it is the resolution professional which takes over the assets and management of the company. So he is in fact powerless to that extent. And then the committee of creditors have all the representative of the creditors who have to look after their interests. So the role and the power of the builder in this situation is really very limited.
okay. Okay, understandable. As you just said, that it has actually happened in past, and couple of builders might have tried to
Yes,
act
yes.
smart in this, but it's a breather that you tell that there is a rigid and strict and timeline, and
There's a
all the
statutory
things are
safeguard.
in place. There's a procedure to get a reality check of that, and if something found fishy,
There's
it can actually
any
be
party,
okay. And it
any
can be, the best part is that it can be actually overruled at the any stage of the proceedings, even
yes,
if it is the last leg of them.
yes, yes. Any
So
party gets to know that he can immediately go and approach the court.
okay, and you need to file an objections with all the valid evidences and proofs,
Exactly,
whatever they
exactly.
have
Because
gathered
that
and documented.
otherwise, then it will be
Obviously,
inconsequential.
obviously,
We
obviously,
have these kind of objections. Oral objections
obviously.
can lead to.
So, sir, now the most important thing which actually comes in my mind by going all this process and everything, is there any see, there are timelines given, but you yourself have just mentioned in the earlier answer that there is a relaxation or little bit of flexibility as far as the timeline is concerned. Can you please tell approximately what is the exact time frame of a person files a claim until he gets some result of his claim before NCLT? Some a broad average, because you have been doing these kind of matters day in day out. So it will be, I guess, obvious to ask you, because from your experience, you can tell what exactly is the exact time, because everybody wants to know how much time we are investing. Money is there, but time is also very important in this aspects.
I'm sure, and that's a very valid question. So, answering your question, the statutory timeline is 180 days
Yes.
from the date the proceedings are initiated. But yes, invariably, it takes time. And let me explain why it takes time. It takes time because every case is not similar. There may be a case where genuinely there are no assets left with the company which we can be liquidated and get the money, either refund or let's say rebuild the project. So in situations like this, it will be a stalemate. So then you have to look for alternative measures, like us looking for potential venture capitalists, investors who can come revive the project. You have to be at the safeguard because everybody wants to have their piece of pie. Everybody wants to put their money where it's safe. So there may be negotiations, one round, two round. There may be competition between the bidders. So this
Okay.
consumes time. But then, having it said that, it is for the larger good. That is either for the revival of the project or to get the best thing out, so that the proceeds can be used uh, uh, to settle the claims of the creditors. Now, 180 days is the outer time limit, but this can be extended up to 270 days. Now, this is,
270.
yes,
Okay.
270 days, which 90 days more, for which you have to record reasons Why are you doing that? So if you ask me, and even you are a lawyer, sir, are there any other provisions or are there any laws where such strict timelines are mentioned? I don't think there is
No.
any provision where you
we
get
we we have we have seen our experiences before NCDRC as well, and
exactly.
we know how people are suffering because of the gap in the dates which have been given. And
And let me tell you something, NCLT does adhere to the strict timelines. We've had cases where even for my clients, I have applied for extension, and you have to do a lot of explaining. It's
okay,
not a matter of right, or it's not an easy ride where you get extension of time. You have to really explain the court why you need the extension of time. So it is. I'm saying that the strict timelines are followed, and
okay,
are followed in almost all the cases, except
okay.
for in situations which I've mentioned to you, where it is
Understand.
actually not viable. Because if there's no point where when there's no cows to be fetched back by the end of the day, so there's nothing left. There's no point sticking to the timeline.
Understandable. Pretty understandable. So, Mr. Massey, say per se there's a situation now where the company is under liquidation and there is no bidder, no investor.
Hmm.
Assets are also down.
Hmm.
Is there any still any hope for the home buyers to
Hmm.
can get their money back? Or the matter will be just sanitize like that?
So if you're asking me whether the project can be handed over to the home buyers,
No, that is not my question. I'll ask that
okay,
because that is also falling in my mind right now to ask you.
okay,
But right now, my situation is that there was a claim against
yes,
a builder.
yes.
The resolution professional tried his level best but could not resolve. The
Hmm.
company goes for liquidation. Now there is no investor. Nobody wants to invest or to take over that particular project. In
Hmm.
that situation,
Hmm.
is there any still any hope for the home buyers? Or if not, then what is the situation left?
So, if the as I said that home buyers are participants, you can obviously look for alternative builders. You can ask the the development authority, local development authority, to
Okay.
take up the project. So these options are available to you. That is asking for, because I don't think builders would the home buyers will do the building themselves, right? So they'll have to look for the local authority either, or some builder. So yes, that option of getting in the local authority is also available, where you can make an application to the court to get the local body representative here, and let them
Okay.
submit a kind of a proposal how to go about it. And also the home buyers themselves can put up a resolution plan detailing their what is their plan of reviving it. Can they generate their own funds? There have been cases where the home buyers have pooled in money to revive the project when a situation like this, as you mentioned, arose.
Okay, okay. So meaning thereby is that actually it sounds very difficult, but as you just told that it has a possibility.
Yes.
Well, there could be a possibility. It's the next question which I really want to know from you is that there could be a possibility where home buyers make a committee out of it, and the construction can be completed under the supervision of the government authorities.
Yes. Yes.
Okay,
And it has happened in one, two cases of Huda.
okay. So, matlab, there are examples which actually fit into this answer, and it has actually happened with where there was a
It
committee
has.
formed by the home buyer. But it seems to be a very tedious job because in any particular respective project, there are hundreds of home buyers in that project. How I don't know how they have clubbed together
See,
on that.
I cannot tell you what is the last update, but yes, orders were passed and things were initiated. This includes JP Callispo. This includes Sampata Livia, if I'm not mistaken. This was a project of PSA Implex, I think in Noida
Okay,
somewhere. And JP Callispo was there. There are two, three others. Piyush Heights, I think, and DSK Sadhufuli. So this was Maharashtra case. But here the Resident Welfare Association and the home buyers, they got together, and they made applications, and they licensed with the local development authorities, builders, and they pulled in the resources to get the project completed. When a situation like this, as you were mentioning, when there are no assets left or nothing like this arose.
Okay. So correct me if I'm wrong, what I have understood, but this, what you have just told us, is only restricted when the home buyers actually want a flat or house, whatever they have invested for. But it will
Exactly.
certainly not, if, and correct me if I'm wrong, it will certainly not work where they want their refund of the money. So there's,
Exactly. In which case the assets, whatever left, including the project, has to be sold as it is, uh, which is the land and whatever structure has
okay.
been, and thereafter
So,
the money has to be returned.
so is there any mechanism in the way the money, whatever assets are there and whatever projects are there, if it has to be distributed among different creditors? Is there any mechanism or a list or a priority list of who will come first, who will come later? Is there anything of that? And if yes, then where in that list the home buyer stands actually?
I would say home buyers would come at the second or the third position. The first right is that of the workman wages and the secured creditors. Now, it is
Okay.
a I don't want to make a disputed statement. It's a kind of a gray line that whether the home buyers will be secure, because this is a very debated topic. Because in certain cases, depending on the builder buyers agreement, the situation may arise, or the interpretation in law can be that the home buyer is a secured creditor if he has some kind of a lien right or mortgage right over the property in which he is invested. But in most of the tripartite or BB agreements, you also where that's not the situation. But the priority of debt, as far as the IBC, is governed by Section 53. And under Section 53 is the workman compensations, which get priority, followed by the bankers, and then the financial creditors. There's
Oh, yeah.
also
The same way in the winding up, which used to happen,
exactly, it was the
first
old
the
regime.
amount of laborers, then the secured creditors, and home buyers being the unsecured creditors, if not the
Exactly.
specific
Yeah.
agreement says so, as you
Right.
just told. So technically, they are little below, because in that case, Mr. Massey, is there any hope that they will ever see their money back?
So I'll try to answer it by putting another question, which is the other forum where you have the hope of getting the money back. Because you see, other forums, including RERA, will only pass an order for recovery, right? But then you have to go in execution.
Yes.
That's the same with DRT, but because DRT is only meant for banks, but that's the case. Same case with Consumer Forum and also with the district courts, the civil courts. This is the only court where you are part of the mechanism of execution,
Yes.
where you don't have to file execution separate petition, where you are before the same court where you will get the money, and you are a process. You are involved in the process in which how the money or how the assets are to be sold. You are participating. So right now, this is the best viable option. There will be questions, of course. There will be a lot of drawbacks, or let's say gray areas, which will improve with time. It's
See,
not a perfect code.
it is actually very obvious, and you are absolutely right by saying this. Why? Because this actually law, if I understand this law, it is still evolving,
It's
and
evolving law.
all the gaps are for a time being. The day it was actually notified, now what is the stand? It's a huge difference between both the drafts.
Absolutely.
Which the thing which came initially and now what we are actually reading is total different, because they
Absolutely.
are from time and again changing, and you can say they are pinpointing the gaps and they are trying to cure that things.
Absolutely. Absolutely. Like the best example is that home buyers were not even thought of probably at that
Yeah,
time.
that
That
that that
that
it was a debate, and now it is actually a
and now
wonderful
we have
news for us that they are financial creditors, not
and
rather
now
operational creditors.
Tariq pass a charge as far as a unsecured, or let's say secured credit is concerned. If you're a secured creditor, you have a charge along with the bank, so you're
Right.
standing there.
So technically, what I have got and I have understood that the other mechanisms, say RERA, and there are a lot of matters before NCDRC, because initially there was no NCLT at that time when all the projects were being, these cases were being filed before NCLT. But now, due to the strict guidelines and the time frame and everything, and the authorities monitoring the whole proceedings, I guess right now the NCLT will be more viable if a fresh home buyer who is actually wants to opting between the forums, which is the better pick. So I guess, if I'm not wrong, the NCLT will be scoring a bit more marks than compared to the other forums. If I'm wrong, then you can kindly correct me.
I would agree there, to the extent that if the project can be revived, and also in case of insolvency, you are a part of the proceeding and you are a part of the execution proceedings. So, and there are strict timelines. So I would say yes, safely, that you don't have to go through the drudgery of execution, because what happens in all these other courts, NCDRC, RERA and all, that even if you get an order, let's say in 6 months time or 1 year's time, if you're very lucky,
No, it never happens. Sorry for that, but it never
yes.
happens. 1 year is a date difference between one date and another date.
It may, yes, especially in the COVID. But I'm saying, even if you are very lucky, you get that. But then, execution will take probably 2 years.
Exactly.
So it is even better to be in NCLT, where all the assets of the company are in control of the NCLT, the committee of creditors. They have their say. You have your say. You have the voting right there. So and you have a strict timeline. So I think, given of all the options, this would be the best option. However, the answer may differ if the builder is solvent and he's in a position to pay the money.
Okay. See, now there's one aspect which I really want to ask you now. You had time and again mentioned that the home buyers have an opportunity to participate actually in the resolution process and to all the, you can say, redevelopment of that company. Now, when you say that, let's presume that in one project there are 500 home buyers. All 500 will have to take part, or they will make a committee out of them?
No, there will be,
give them authority that whatever they'll decide,
Right.
it's applicable to us also. How this all mechanism work? Because it will be a huge rush of people and nobody will understand anybody.
So generally, these things are governed by the RWAs, that it's the officials of the RWAs who represent the home buyers. But if there is no RWA, then the home buyers can have a meeting, then themselves do some kind of internal election, or if not a formal election, then they can have a letter signed by all the home buyers that these 2 or 3 people are the people who will be representing them.
Okay.
So so the voting rights depend on the amount of the percentage of claim which you have over the debtor. So let's say 40% of the claim is of the home buyer, so 40% vote will be of the home buyers, which will be a big, let's say, a kind of chunk of vote, deciding vote.
Okay. See, one more thing.
Sure.
Say there are 500 home buyers in one particular project, and out of that 500, 200 odd people came together, made a committee, elected some people, participated. But remaining 300 does not know at that time. They couldn't be contacted, or for whatever reasons. Now, the whatever decisions has been taken, are that applicable on the remaining people also who actually did not participate?
So here, that's a kind of a trick question also, because as I told you, that claim list is drawn, and based on the claim list, it's decided that what is the claim of that particular party, or let's say a group of creditors against the individual. So the claim, it's based on the claim list. So the name of those people should be included in the claim list. If it is not, then there is a provision that whatever is left out, then that amount will be utilized to satisfy the claim.
Okay.
That is the reason I always emphasize that you please file your claim. Whether you be a part of the RWA or not, you file your claim individually, and get your name included in the claim list.
The crux of the matter is that you have to be there in that list.
Exactly.
If you're not there, then there will be a little trouble for you.
Exactly. Then it's easy, and in law you can say that you missed the bus, and whatever left is, then you'll have to wait for your turn.
Excellent. So, Mr. Massey, I guess I must say that it was quite informative, and you have actually beautifully explained all the aspects. And I hope our audience have got some value out of it, at least in understanding what exactly is the mechanism and what is the procedural limitation, pecuniary jurisdiction, and all the remedies and powers and rights which the home buyers have under IBC code. So I guess we should stop this session right now, and I request Vipul to now take over. So I just request all the listeners who are attending this session, if they have certain any question to ask from Mr. Massey, you just unmute yourself and you can straight away ask the question. I guess Mr. Massey answer will satisfy you. So if there is anybody who has some question, kindly please unmute yourself and ask that.
Mr. Singh, with permission, may I just ask one question?
Yeah, sure, please do that.
Thank you so much. Mr. Massey, sir, thank you so much for this wonderful knowledge sharing. Sir, I have a question. Can a home buyer approach 2 or more forums simultaneously for his for the redressal of his grievance?
So technically he can, yes, go to the other forum, but what happens is there is a moratorium under the IBC. So once those things are initiated, then all the remaining proceedings, they get stayed. So there may be a situation they've already filed a claim in the NCDRC or let's say RERA, and then the proceedings goes to NCLT. You will have no other option but to come to NCLT because you will have to file your claim there.
Okay. Anyone else have some questions to ask?
Okay, I would like to understand one thing. Let's say there is a project where the home buyers are approaching and financial creditors, and now they can somewhere they reach a resolution कि इसको बनाते हैं project को. उसमें बिल्डर की भी अभी कुछ अनसोल्ड इन्वेंट्री है. Who controls that unsold inventory?
So that unsold inventory is technically in the possession of the RP, but that depends what is the stage of the insolvency proceedings. What happens is that once the insolvency proceeding starts and notice has been issued and the CIRP process, as it's called, has started, then the IRP takes control of the management of the company and the assets of the company. So if you're saying that
the IRP, no.
So it's in the IRP, exactly. So that asset still remains with the IRP. It cannot be sold by the builder.
But can it be sold to settle the dues otherwise?
Of course, yes.
Okay. मैं इसको सवाल को और थोड़ा सा specific करता हूँ. Let's say there is a builder who had 500 units in a project, जिसमें से 300 were sold, 200 are unsold. और जो 300 उसने बेचा, उन लोगों से पैसा ले लिया, उसमें से कुछ लगाया, कुछ नहीं लगाया. अब let's say the entire project had completed in say 500 crores, and he has already collected the 300 crores from these 300 buyers. To complete the project, these 300 people put up extra money. Can they recover this money by selling the unsold inventory?
So now the thing is, if you're saying that the project involved 500, right? So technically, if you go by RERA, that amount has to be kept in a separate account, right?
मैं ये बोल रहा हूँ कि 500 करोड़. Let's say there were 500 units, 1 CR each. So 500 crore for completion.
300 has already been paid.
Been built, 300 was sold, and 200 unsold inventory. These 300 people finally say
you think 200 were unsold. Okay, in that sense, yes. But what amount is to be recovered? Is it for delayed possession or for what? What is the claim?
delayed possession, balance जो बनाना है उसके लिए जो पैसा चाहिए, तो this 200 units would they be part of the resolution? Would this be an asset?
So, like, why is it that selling it off is the only option? Yes, it can be. If you ask me, if there
Builder
is
के
no,
पास तो पैसा है नहीं ना पैसे recovery करवाने का, ये unsold
No, but
inventory.
I understand that, but if this is a part of the property, and probably a new builder or developer can be brought in to purchase that part, that money can be then utilized to sell
एक
off.
ही बात है, मैं वही
Right,
जानना चाह रहा हूँ, चाहे थर्ड पार्टी दूसरा डेवलपर
right,
आगे,
right.
but this belongs to the creditors only. This 200 units.
So yes, the creditors includes the banks also, by the way. So all as I've said, that the priority of debt is like this: the workmen's, the banks, the home buyers. Generally speaking, not a strict kind of order, but yes, in a situation like this, if there is an inventory which is there, the IRP has the right to sell it off to satisfy the
This
debts.
becomes a part of the available assets.
Exactly.
All right. Thank you. My question is answered. People can ask questions by raising their hands.
I do have one more question, sir.
Sir, please.
Can an individual approach NCLT for voluntary insolvency?
So this is a question which is a gray area, to be honest, because the Insolvency Act provides, yes, they have the power and they are the body, but the provision has not been notified yet. So that is a gray area.
So technically speaking, there is a provision, but it's not applicable till now.
Exactly.
Okay. So
In law, it is there, but it's not been notified yet.
there could be any specific reasons why they are not notified. A lot of things in IBC.
I think probably because initially it used to be the Insolvency Act, the Provincial Acts of Insolvency earlier, and then there may be a backlog of a lot of cases. Probably it is for this reason,
Maybe.
that the old regime, because all of that will then have to be shifted to NCLT,
Yes.
right? And NCLT is already burdened, and the individual claims are small. You see, right? It used to be earlier 500 above.
Yes.
Right. So anything above 500 would then come to NCLT. So this may be one of the reasons, probably. That even I have been working on some matters, and specifically this one, that if this happens, then can the individual go to? So yes, the law is there, the provision is there, and specifically says Part 3, in fact, is specifically of the IBC is for the LLPs and individuals. It says so, but the provisions have not been notified yet.
See, my now question is little different from the home buyers and builders. If I'm not wrong, Section 95 deals with the partnership firms.
Mm-hmm.
So you just said that Chapter 3 is not notified. So
No,
aren't they
as far as
going
the
to
individual,
95?
as far as the individual is concerned, yes.
Okay.
For the LLPs, I have also dealt with the LLPs.
Okay. Because Section 95 caters that.
Yes.
And it also now includes the guarantors of the corporate debtors.
Yes. So LLPs, they've done that. In fact, I've personally done 2 matters for LLPs, but not for individuals yet. I think this may be one of the reasons, and probably there has been 1 or 2 cases where they've kind of kept it in abeyance, or they've not entertained it for individuals. So not the Delhi NCLT. So this may be a issue.
So I guess now, Vipul, if there's no more question, then you take.
If there's no more question,
question?
I'll beg your pardon.
I'm saying, do you have a question?
I don't have a question. It was a very informative talk. I just have my gratitude to. Thank you.
Thank you
so
so
much.
It was wonderful. It was very informative for me also to take such tough questions, I should say, because IBC, as you said, it's a new code and it's developing. So for these new laws and the procedures, it's the questions are also very Like for example, somebody asked the individuals. So that's there are a lot of gray areas, there are questions, but as would have it with a lot of laws, it develops with time.
Yes,
Yep.
exactly. Was my
Thanks to both of you, sir.
pleasure.
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 It was all mine.
All right. Good night. Bye.
Wonderful,
Right.
interesting.
You gotta focus on yourself, on your faith, on your dreams, on